have one? The first topic we'll discuss today is the issue of vacancy inspection of uses. Now, if you're a realtor, if you're an REO, agent, or whatever, you know that banks have a right under the terms of a mortgage to make an inspection of the property to see whether or not someone's abandoned it, to see whether or not it's being upkept, and the condition of it. And for the folks that have abandoned the property, the banks can go ahead and take possession and secure their asset. What we're seeing, unfortunately, is a trend where banks are using vacancy inspections as a collection method and really kind of an intimidation tool as opposed to truly verifying that somebody's living in the house. And all they need to do is go out to the house, confirm that the car's in the driveway, the mail's getting made, sent to the mailbox, and there's some, upkeep of the house, if the grass isn't, overgrown, and that will go ahead and confirm with the bank that someone's living there, they've met that obligation to say, yes, vacancy is existing. What banks are now doing is using that as a collection method. They're sending out an inspection rep, making certain comments to the homeowner, making some intimidating and harassing kind of comments. And the worst story we had regarding this happened Christmas ago. And we had a case where we're representing a homeowner in a foreclosure, also suing the bank back for their misconduct. And the property inspector comes on a Saturday afternoon, December 18th or 19th, and says to the homeowner or client, what are you going to tell your kids about why they can't have Christmas this year? What are you going to tell your kids about why they've been thrown out of their house tomorrow? You know tomorrow's a sale date. That Monday's a sale date. You know that, don't you? Of course, the client freaks out, calls us on our cell phone. We're able to get involved over the weekend and confirm that nothing's happened and they haven't responded to our lawsuit yet. But what you have is you have these people using that as an intimidation method and a means to go ahead and collect on the debt when it's really not for that purpose of verifying vacancy at all. So in the outline, I've actually set forth the terms in the mortgage that talk about this. And the one term is preservation, maintenance, and protection of property. And the next section of that is protection of lenders and property rights on the security agreement. So we can go in and look at that. Yes?
At what point do they typically do this? How far in advance of foreclosure?
The sad thing is they're doing it pre-foreclosure now. They're even doing it upon default. Typically they should do it once a foreclosure has been commenced, a month or two into the lawsuit itself. But there have been scenarios where they're going ahead before the suit actually is commenced, after default, after acceleration, before a lawsuit. And they're using it also for lockout. So people that are not in the property, they are changing the locks, putting lock boxes on there and saying, you've abandoned it, we're going to go ahead and take possession. Now that's after the default, but far before any court said you're entitled to take possession of that home is yours.
And we've actually had an issue where it was prior to suit, where they had a vacancy inspection, but the clients were still at their home, and kind of similar to the scenario that Charles just talked about, the person that was conducting the vacancy inspection said, oh, your home's been foreclosed. This is going to be sold. You need to get out of here soon. So to get that person to leave, and they left without hiring an attorney. After they left, they contacted us and retained us, and then we looked at the public records to see the status of their suit. There hadn't even been a foreclosure suit filed, so there's no way that there was an impending sale date without a foreclosure suit. But in the meantime, they also used that, now that the home was vacant, they went in to secure the premises. Like he said, they went in, they changed the locks, but to do that, they broke some of the windows, they damaged some of the pipes to walk around the home to secure the premises. And so when the clients eventually were able to get back into the house because we were involved, we also had this issue of now we have to sue the bank for all the disrepair costs to the home. So it happens at different points in the case as far as the vacancy inspections, but we are seeing that more and more prior to suit.
And what can they do though if they do determine it has been abandoned?
They can retake possession. They're allowed to change the locks. They're securing their assets. So the idea is you don't want to have a squatter in there. You have someone come in and break in, that kind of thing. But what we tell our clients is that when someone comes to your door with a vacancy inspection, and say two or three things. Say, one, represented by counsel, here's their attorney, here's my attorney's card. I'm living here full time. Thank you very much, goodbye. That's all the inquiry should be, because once someone confirms that, there's no need for them to be there on property any longer. So that's a way to head that off in the past. Also, we can go ahead and send correspondence to the lender in advance of that even happening, saying, we're just going to confirm that our client does remain there, lives there on a full-time basis, and here's a copy of their water bill. Don't go to their house. Any questions about vacancy inspection issues?
They go, knock on the door, nobody's there. They consider it vacant? Or do they look, if they look in the window and see there's furniture and stuff like that?
They'll make an objective assessment of the property, so they'll see if there's mail piled up in the mailbox, if the grass is overgrown, if there's furniture inside. Exactly. And really, the determination between abandoned and unoccupied is very subtle too. So, yeah, you're away for a 2-month vacation. Is it abandoned? Of course not. Is it unoccupied? Yeah, it is. So, If it exists.
You know, there was actually an interesting story in the news where a woman actually went on an extended vacation, and
They took possession while she was gone.
actually they secured her home, but she had a macaw in her home, and she had someone to come every day to check on her bird, and they did the vacancy inspection, and they thought that no one was there, even though the house was fully furnished. The bank was in a rush to take it back. Yes, ma'am, I had possession. She came back, and her furniture was gone, and her bird was gone, and she was able to eventually find out where everything was and ended up suing Bank of America. But even worse in that scenario was that home wasn't even in foreclosure. She wasn't even behind on her payments. But they accidentally took possession of the home that wasn't even subject to the
And they put another tenant in there. They threw her tenant out and put another tenant in there in the next maybe 2 weeks. And she wasn't even in the process of being foreclosed on. She was up to date on everything. So, you know, what do you do with these people?
Send them back. That's the answer. You had a question back?
Yeah, this question is based, I guess, on a national level, not just in Florida. And I don't know what we're discussing today. Is it all Florida related, or in some cases nationally with?
That's everything. The actual nuanced legal stuff before.
I'll give you a case that didn't happen in this state, but very simple, where a client knew what was happening. You know, the market's tumbling, et cetera, preserved the home, took care of the home, et cetera, took the proper steps, had to do what they had to do and move on. The situation is in default, negotiate with the bank, send them the paperwork in every 20 days, we want new stuff. Also, trying to renegotiate with them, no help, and we'll talk about Wells Fargo more or less, which was at the worst, and we're going back now a couple of years since this has happened. They went ahead and did a complete lockout. I mean, damaged the house, the whole 9 yards. Wouldn't negotiate with you in any way, shape, or form. There's a short sale under contract on the table, pending all their stuff. And they're still going ahead and doing all this stuff. And then meanwhile, billing the client severely for upkeep, maintenance, saying they're cutting the grass, and that ain't truth. That's complete lies.
There's one universal truth we've learned with banks across the board is that the loss mitigation side of the bank does not communicate with collections, and they don't communicate with their attorneys. So you're going to have these multiple lines of attack. One, I have a hearing coming up this afternoon in Brooksville, I'm going to go to next, where the bank told you, the bank said, we're giving you a modification. In spite of that, the bank went ahead all the way forward through foreclosure to obtain judgment against our client. They retained us after the fact, but at a point in time where they were told that we're giving you a modification. So they don't communicate. These lines of communication are separate, unfortunately.
Is there any kind of recourse there whatsoever for a client that it was unfair and unjust the way this all happened?
We've been suing on behalf of clients for what we would call negligent underwriting of loss mitigation documents, negligent underwriting of loss mitigation requests. There's been a class action lawsuit against Chase filed up in the federal district in Massachusetts, where Chase was being sued for just that issue. The borrowers were giving financials, they were giving everything, cooperating, and you had Chase intentionally age documents, intentionally lose documents, and otherwise just frustrate the whole process of any kind of loss mitigation, which results in no modification of the loan, no assistance at all. They had a practice where they would actually literally put aside documents that came in or financials, and then look at them about a month later. Well, they were already aged by then. They'd go ahead and say, well, those are your documents, but they're old. Well, you got them, they weren't old. So they're being sued in federal court in a class action lawsuit. We're suing a bunch of them ourselves independently in state court here for those same issues. Chase, ironically, is one of them too. Yes?
What is happening where, not right now, but maybe like 6-8 months ago, where the banks were telling you to intentionally that they couldn't modify your loan because of the fact that you were in default, and not to pay for 3 months, and then go through modification, and then after a 6-month period of modification, you're denied, and now suddenly your house is in foreclosure.
You mean the phrase fraudulent inducement? Because that's what that is. I mean, they're inducing you into a temporary modification, telling you that there's some hope on the horizon out there.
But you have to be in default to do so. That's the only way you qualify.
And the beautiful thing is, we have our clients deposed all the time in these cases, and I love when the clients, the attorney asks the question wrongfully, stupidly, why are you still making your payments? Well, the bank told me to stop making my payments. They told me to go into default because they couldn't help me. Right. So that's also a universal standard among banks, nationwide. They have an internal underwriting standard that requires a default for any kind of loss mitigation assistance. They're not going to help you if you're current, period. So.
And what is that called again?
Fraudulent inducement. When they tell you, we're going to give you a modification after you make 9 days of payments.
Right.
You ask them, what are the terms of that final modification? Don't know. We'll tell you in 90 days. Well, people make their payments for those 90 days, and then they get denied. Again, you've encouraged them to pay 3 payments with this false promise of a later.
Well, they don't so much as tell you you're going to get a modification. They lead you to believe that the only way you're going to qualify for us to even look at a modification is you must be in default. And you're like, I don't understand. You're one of the good guys doing everything you can to survive. That client's a good person, and that's exactly what I'm trying to avoid, going into default. Can you please help me with perfect credit?
And their answer is no.
Right.
Thankfully, it died in committee. It was almost passed by really a whisker this past term, but died in the Senate committee, thankfully. I'll let Jay go ahead and
It did. It died in the Senate, but you want to keep your eye out for these provisions that were included in it, because they're more than likely going to propose it again. The banks have spent roughly $26 billion on these settlements. They're going to want to get their money back, and they want to get it back through legislation. One of the things that they proposed was non-judicial foreclosures. Now, without judicial oversight, this allows the banks to be their own judge and jury. This allows legislators, instead of judges, to define fundamental fairness. A non-judicial foreclosure would allow a bank to initiate a public sale of the house without any entitlement to defense by the homeowner, and without any oversight by the courts. And this is very important because of robo-signing and other violations that have been going on. They included a provision for fast-tracking of foreclosure cases once they're filed. Now, we've seen banks have exhibited fraud, negligent underwriting, and other violations in the past. So allowing these non-judicial foreclosures fast-tracked, they say, will help unclog the courts. But in doing so, they're going to remove a homeowner's due process rights. This allows for lending violations to slip under the radar unnoticed. If we were to put it in a criminal context, it would be like fast-tracking felonies, where we remove due process rights from someone. This is in a civil context, just removing the home from somebody without judicial oversight and as quickly as possible. Now, one of the provisions was a court must enter judgment within 45 to 90 days for uncontested foreclosures. This is also an attempt by bank lobbyists to fast-track the foreclosure process, so the quicker the foreclosure is finalized, the less time there will be to seek an attorney or investigate their procedures. There's 2 different, and these are like almost conflicting provisions that they wanted for attorney's fees. They wanted to repeal Florida Statute 57105, which allows sanctions for attorneys that bring cases with unsupported claims. For example, if they filed for foreclosure but they didn't have standing, they didn't own the property. Now, this is an attempt to safeguard the plaintiffs by denying the defendant seeking attorney's fees that the money that they had to spend when the plaintiff brought this lawsuit against them. And on the other side, the bill sought to entitle the prevailing party to attorney's fees. So on the one hand, you have you're equipping the banks with a shield to defend them against claims that they bring, foreclosure claims, when the defendant has a case against them and says, this was unsupported, you can't, you need to pay us our attorney's fees because I had to go out and hire an attorney. And on the other hand, they wanted to give the prevailing party fees so that, once they have made it past that threat, now they can go after the homeowner for money for their fees. There's also a provision included that was the automatic return of promissory note to lender upon the dismissal of foreclosure. An example of this proposition would be the homeowner loses their home, has a deficiency judgment against them. We'd stop right there, but now they want a third, so that without any order from the court, they can automatically get back their original promissory note, where they could perhaps send it to sell it to a debt collector. So this is 3 times the injury to the homeowner, and the banks wish to do this without judicial oversight and as quickly as possible. Finally, there's challenges to set aside wrongful foreclosures would be limited. They want to, the quick foreclosures, and they want them to be irreversible. So this provision would not allow the homeowner to get the house back. The only thing that they would ever get back would be money, but they would lose the house once it was sold. So those are the provisions that stuck out the most, and if you guys have any questions on those, I'm gonna refer to Charles, but.
Two bits of context. One is that this is the third time it's been proposed. What happens is the Florida Bankers Association actually drafts up the legislation and gets a sponsor, this time it was Kathleen Pasadomo out of Naples, to say it's her bill. And she adopts it as it's her bill. Now she's, actually her job that she works for is a bank attorney doing foreclosures in a residential context and in her life, so clearly she's a friend of the banking industry towards you, is swinging, okay? They're not just selling you a loan, they're telling you, we're going to give you an option that's good for you, it's going to help you out. But they're misrepresenting the fact why they're asking for those things. So that's where the problem happens. If they told you straight up, hey, we're asking these questions because we want to maximize our money, we don't make sure we're taken care of. Forget about you guys, worry about us. It would be totally lawful. This way, doing it this way, again, we get into the issue of is it a fraud? Is it cloaking up with fraud? Is it fraudulent inducement? Probably is the answer to that question. I'm going to go ahead and let Erica talk about the issue of standing deficiencies and logo signing and false documents, which is something that's impressive quite a bit.
As far as standing, any person that files a suit, whether it's a person, if it's a corporate entity, you have to have standing to file a suit and to maintain a suit. And standing in the context of foreclosures is the most important aspect of the case, actually. And Florida law is very clear that a party that seeks to foreclose on a mortgage has to have standing to sue, which means that they're the owner and holder of the loan. Also, a plaintiff, a lender, that's seeking to foreclose, at some point during the case, they have to file the original promissory note with the trial court, or in the alternative, they have to file what's called a lost note count. And there's a very specific Florida statute which lays out what they have to plead with regards to a lost note count, and under what circumstances they can even allege that the note is lost and they're seeking to reestablish it and they have a true copy of it. Specifically, this appellate district has reversed what we call a summary judgment. A judgment has been entered in favor of the lender where there's been a dispute of material fact as to the ownership of the note and mortgage. In fact, courts have even sanctioned plaintiffs and sometimes plaintiffs' attorneys for filing suits without having standing. Specifically, there's a case called Country Place Community Association versus JP Morgan Acquisition Corporation, where the court held that JP Morgan lacked standing to foreclose because it didn't own or possess a note and mortgage on or before filing suit. And because it knew it lacked standing, or should have known that it lacked standing to foreclose on the property, the court went ahead and sanctioned the bank. So it provided basically a monetary punishment to the bank and to the attorney for filing suit without having basically all their ducks in a row. And this kind of leads into acquiring standing after the suit. You can't acquire standing after you file suit. Standing is something that you have to have on the date of filing suit or before filing the suit. And it's not something that can be done retroactively. And that's really important because we do see a lot of lenders trying to retroactively establish the right to sue. So for example, we will have a plaintiff that files a foreclosure suit, and they're not the original lender. They say they've been assigned a debt, but they won't necessarily file the assignment of mortgage, and they say they've been assigned a note and the mortgage. Sometime during a suit, we'll normally file a motion to dismiss the case for lack of standing because they don't have all the documents they need to foreclose. They'll go ahead and ask for permission from the court to amend the complaint to include that missing document. But if that assignment of mortgage wasn't executed until after they filed suit, that can't correct the deficiency. That can't correct the defect with the lawsuit. Their only option, basically, to correct their lack of standing would be to file a new suit. They'd actually have to dismiss that suit, pay a new filing fee, pay another service of process fee to serve the homeowners again, and file a new suit. So because they don't want to expend those costs in filing another suit, they usually do try to amend in hopes that no one's going to catch their original mistake. And actually, we had a case the other day where they filed the wrong assignment of mortgage. It was an assignment of mortgage that wasn't for those homeowners. It was for a property, not even in Pinellas County. It was the Pinellas County suit. It was a Brevard County property. Wrong assignment of mortgage, didn't even have our clients' names. We pointed that out, filed a motion to dismiss, and they actually said, okay, you're right, we accidentally filed the wrong one, but we really do have an assignment of mortgage. It's executed before the date of filing, So we're gonna go ahead and introduce that. They asked the court for permission, and the court said, go ahead, you can file your assignment of mortgage as long as it's executed prior to filing of the suit, because you can't, once again, you can't cure that defect. So they went ahead and they said, oh, and well, we're gonna put out a new copy of the note, because originally they had filed a certified copy of the promissory note. But this new copy that they went ahead and filed now had an endorsement in blank, which didn't exist before when they filed the suit. So of course, that's something else that we're attacking, because if that document existed, if that note was actually endorsed to someone at the time of filing suit, well, why didn't you file a copy of that promissory note with the endorsement? So that's something that we do see very, very commonly. It's a routine thing that banks try to do. They won't have all their papers in order. They might not even own the note and mortgage at the time they file suit, but they figure they're going to own it pretty soon, so might as well just get everything underway. And that's, you can't do that. For the law rules that you cannot do it. You can't acquire anything after the fact. It has to be before filing suit.
And they want to fast track that so that you don't notice and see things like that, is what they proposed in that Florida Fair Foreclosure Act.
Yeah, because if you have a time period of 45 days, you might not even have time to find an attorney, and next thing you know, your home's already foreclosed, and that lender didn't even own the note at the time they did it. And like Charles said, we have a case that's on appeal that one entity filed suit, and it looked like it was changed during the pendency of the suit. It changed hands 2 or 3 times, and so now we're appealing that issue, because you can't keep changing also hands while the suit's going on without letting the court know, because now who has the right to foreclose? Who do we even owe money to? If we want to make a deal, who do we make a deal with? And that's something that we really have to investigate, because you can't just trust the bank saying, well, trust me, I own it. No, well, where are the documents then? Do you have any proof? You're a bank. Banks do a lot of paperwork. So when they say, oh, we don't have the paperwork with us, that's a pretty bad sign. Banks like to leave paper trails, and if you don't have a paper trail of how you came to own this note or mortgage, it's probably because you don't.
And really, the short answer on that is this, okay? Before the bank steps foot in the courthouse to think about filing a lawsuit, they better have crossed every T and dotted every I, meaning they own that loan before they even think about filing a lawsuit. They're not doing that. They're filing suit and say, ask questions later. We'll go ahead and fix it later. They can't do that. The consequence of that is this, okay? Foreclosures then become fraudulent. So does a collection. So say I, Charles Gallagher, decide, you know what? I'm going to sue Michelle for foreclosure. Trust me, I own your property, but I can't prove I own your property. How is that collection effort before suit, as well as the foreclosure, not an act of fraud and collection? And that's why we sue banks for foreclosure fraud. Because if they don't own a loan on day 1 of the lawsuit, and think of it this way, banks are going to report the credit reporting agencies default and foreclosure status during a lawsuit before foreclosure lawsuit. If they don't own a loan, how is that not surrender of time? If they call you and say, pay us money, and don't own that loan, how is that not collection fraud? So people are taking too much of a defensive tack on things, and we go a lot more offensive in that regard. So that's why we sue banks for the misconduct.
As a homeowner, though, how would you know if they really own it? How would you find
You
out?
have the right under the federal law called RESPA to make a request upon your bank, on the owns your loans and services your loan. Now, before this whole securitized mortgage morass occurred, the records would give you the answer to that question. If your loan was with SunTrust, and SunTrust said, we're going to go ahead and sell it to Wells Fargo, there would be an assignment of mortgage in the public records from one bank to the other. And at the same time, SunTrust would send you a letter under RESPA, so would Wells Fargo, so you would know that. Because of this whole mortgage-backed securities and bundling of mortgages and selling their stock, that's where some of the money was lost. And the bank's taking the position that, you know what, we can tell you, trust me, I own the loan. That's all you're going to get, okay? Or the bigger issue, which I'm going to get to in a second, is this issue of endorsements and blank. They're saying, we don't need to file an assignment of mortgage. We're just going to go ahead and endorse the note. But we're going to endorse it in blank. No date, no person it's in favor of. They're just saying we're going to sell it, and whoever wants to take it later, when you put time to fill their name in and say they own it. The problem with that, as Erica said, is you can't retroactively acquire standing. So a blank endorsement tells me nothing. It tells me what date was that thing stamped, what date was that signed? No clue. It's blank. Who's it signed in favor of? No clue. It's blank. You know, was it assigned to them before a lawsuit happened? We don't know. So it's proving nothing that you have to prove to get past that hurdle with the court system. Yes?
When these banks do negotiations, you to decide what they want to do, deed in lieu, short sale, foreclose, whatever. since they have prepackaged these things and sold them off as mortgage-backed securities, you have investors out there who will bought these things and expect them to return. So the bank is able to go ahead and negotiate and make the best determination without input from these folks, or do they get a say too?
One thing's out there. One, you have either what's called a pooling and servicing agreement, where that investor gives the bank's ultimate authority to determine what's a good deal for them. Other options where the bank itself receives a power of attorney in favor of them from that investor, from that trust. So one way or the other, the banks are calling all the shots with the investors, letting the investors have much input. Now, a lot of times it's a problem because if we make an offer, a settlement offer, is that really breaching the party in charge, the trust? Very likely not. So we'll file what's called a proposal of settlement with the courts, such that they have to go ahead and give a document to the investor so they know what offers being made. But yes, you get into a problem of, are those settlement offers being conveyed timely? Probably not. You know, and the other issue is, if you're going to do a deal with them, how do you know that bank has authority to do a deal for the investor? So before we do any agreement, before there's any kind of deal, whether modification or whatever, we always have a settlement agreement beforehand. And we include two things in that. One is reps and warranty language, representing and warranting that the bank has title to the loan or has got authority to the loan, so they can prove it up. So, and if they don't, the bank automatically is in default. And two, we ask for what's called third-party indemnity language. So say we have a deal with this bank.